Hi, and welcome to the Arbitration Conversation. So this time we have a special treat, another mentor of mine, Professor Chris Drahozal. Professor Chris Drahozal, he is the John M. Rounds Professor at Law at the University of Kansas School of Law, just partnering me from Missouri, and he's the Associate Reporter for the Restatement of the U.S. Law on International, Commercial, and Investor State Arbitration. So thank you for being here, Chris.
Thank you for inviting me, Amy.
Well, this will be fun. So what we're going to talk about is a U.S. Supreme Court case, which is going to be argued this fall, which is Henry Schein, Inc. versus Archer and White Sales. So before we get into the question for cert and what's happening in the U.S. Supreme Court, would you mind filling us in on kind of the background?
So this is actually round two of the Henry Schein case. There was a previous iteration that made it to the Supreme Court. And this version, I think, is particularly interesting because it deals with carve-outs from arbitration clauses, which is something that it's basically a provision that says certain types of disputes are not subject to arbitration. Right? So there's a general arbitration clause, certain disputes are carved out from that clause.
And in this case, what was the carve-out?
The carve-out was for injunctive relief. So specific performance of a contract or something like that, which is a very common form of carve-out. I mean, carve-outs are, despite the fact that some sort of advice by experts on drafting arbitration clauses says don't do them, they're actually very commonplace in all sorts of contracts. And so injunctive relief is a common one. Probably a more common one is a variation on that would be for emergency relief, so temporary restraining orders, things like that. And then relatedly, another common carve-out is for intellectual property disputes. So I spent a lot of time working on franchise contracts. A lot of the franchisor's value is tied up in the trademark. And so they carve out from the arbitration clause with the franchisee disputes involving the trademark, emergency relief, right? They're worried about the franchisee doing a lousy job in providing services and having the value of their trademark dragged down. So they want to be able to go to court to protect that trademark, to get quick relief. And as opposed to, it's a little tricky to get emergency relief in arbitration because although institutions have made some changes to address this, you kind of need to have an arbitrator before you can have any sort of decision in arbitration. So you can't just kind of show up and say, we need a temporary restraining order because you have to go through the process for getting an arbitrator appointed.
Yes.
As I said, there are institutions now that have recognized that problem and have emergency arbitrator panels. But even so, it's very common for contracts to carve out emergency relief to allow parties to go to court and get that relief and not mess up the arbitration and not have to go through the arbitration process.
Absolutely. I mean, it makes sense.
Go ahead.
Yeah. No, it makes sense. And I know even when we've talked about arbitration carve-outs before, and even in your casebook, which I've used, there's discussion that, really from a functional standpoint, it often does make a lot of sense, especially for emergency relief. So how did we get to kind of round two on this case?
Well, so the issue in round two before the Supreme Court is whether a court or the arbitrator decides whether the carve-out is applicable. So, this is, as you know, this is sort of a standard issue in arbitration law is who decides what issues, okay? And the first visit of Henry Schein to the Supreme Court was in response to the Fifth Circuit saying, applying an exception for wholly groundless arguments, saying, well, if the argument for going to arbitration is wholly groundless, we don't have to send it to the arbitrator, we can just decide that and go on and deal with the case. And in Henry Schein 1, the US Supreme Court said, no, that's not available. If the parties agreed to arbitrate these issues, you have to go to arbitration. And the arbitrator is the one who has to decide whether there's merit to the claim, whether it's wholly groundless, whatever it may be. Case went back on remand to the Fifth Circuit, and this time the Fifth Circuit said, well, but this time there's a carve-out, and the way the clause is structured, the carve-out essentially, I guess sort of reading generously the terms of the arbitration clause, leaves it for the court to decide whether the carve-out applies. Okay, that conflicts with at least one or two other courts addressing the same issue. And so now it's back before the Supreme Court to decide whether, and I guess one other thing to add to this is the carve-out isn't the only provision that matters in this arbitration clause. The arbitration clause also provides that the AAA rules will govern, right? The American Arbitration Association rules will govern. And every circuit, I think now perhaps save one, has held that one of the rules of the AAA commercial rules and international rules, and basically every arbitration provider, authorizes arbitrators to rule on their own jurisdiction. And the courts have construed that, at least the courts of appeals have construed that unanimously, to act as a delegation clause, that basically even if there are issues that otherwise a court could decide under the default approaches set out by the FAA, once you agree to the AAA rules, that delegates all those sorts of decisions to the arbitrator. So what you have then is as courts have construed it, a broad delegation provision butting up against this carve out. And so does whether the carve out applies fall within the scope of the delegation clause, so that it's something the arbitrators have to decide.
So how do you feel? I mean, yeah, we've seen a lot of these cases, and when we look at sort of the competence as well, and sort of bringing that into do you have any sense of, well, number one, why should we care? And then number two, where the Supreme Court might go on this?
Yeah, so I mean, I've written a lot about carve-outs, as you know. A number of the articles I've done have been co-authored with Aaron O'Hara O'Connor, who's the dean at Florida State. And we have both, basically the articles, and certainly everything I've written takes the position that carve-outs are actually really valuable to parties. That there's benefits to parties to be able to kind of pick and choose, not just as a whole, whether all disputes have to go to court or to arbitration, but to kind of pick and choose. Some disputes may make more sense in court, some may make more sense in arbitration. And so the carve-out itself is sort of a valuable thing to have in there, and actually makes the arbitration alternative more attractive, frankly, because at least some of these parties, if they couldn't carve out these disputes, might not agree to arbitrate at all. They might just take the whole thing to court.
100%. Yeah.
So there is this sort of tension with the carve out and how it relates to the attractiveness of arbitration as a whole. My concern about so what the Fifth Circuit held was that this is an issue for the court to decide, and it went ahead and held that the carve out is met here, and this is a case that has to proceed in court. Given what the Supreme Court held in Henry Schein 1, my supposition is the Supreme Court's going to come out the opposite. I mean, first of all, 2/3 of the time the court reverses in cases it grants, so the starting point is, right, if you just want to pick, it's not 50-50, it's 2/3, 1/3, the case is going to get reversed. But the rationale of Henry Schein 1 was that essentially, if you've got a broad delegation clause, all decisions about the scope of what gets arbitrated or not go to the arbitrators. And even if the argument in favor of arbitration is wholly groundless, it still needs to be something for the arbitrator to determine. And essentially, a way to think about a carve-out is it's kind of a negative scope provision, right? A scope provision says these are the disputes that are within that need to go to arbitration. A carve-out says these are disputes that do not go to arbitration, right? It's kind of the flip side of a scope provision. And it's sort of everybody pretty much agrees, and is if you have a delegation clause, scope questions then are ones that are for the arbitrator, as opposed to in the absence of a delegation clause, they're ones for the court to decide. And if you think about a carve-out as essentially a negative scope provision, and given the court's holding in Henry Schein 1, my reaction is, based on what I know now, and without having, obviously no briefs have been filed on the merits yet, that it wouldn't surprise me at all if the court would reverse here. I think that's a bad idea. As a policy matter, I think that's a bad result, because it interferes with carve-outs, right?
It interferes with your contractual right to create the type of dispute resolution process that you're looking for, and it defeats the purpose of a carve-out if you're allowing for this general provision, which also brings me to this question of just contract interpretation. So if you have a specific carve-out, it seems to me that that should take precedence over incorporating by reference some boilerplate rule from the AAA or whoever that the parties most likely never read.
And that's absolutely right. The twist to it is the specific if the specific clause doesn't address the who decides issue, essentially the contract is silent on that issue. And then the boilerplate AAA rule comes in and fills that gap. But I guess I would say two things. One is, yes, this is problematic for carve-outs. And if you think about the example we talked about already of carve-outs of emergency relief, right? If the Supreme Court reverses in Henry Schein, what that means is before you can go to court to get emergency relief, you have to go to arbitration to decide if emergency relief falls within the scope of the carve-out. And by that point, it's too late. And frankly, even the emergency arbitrator provisions that have been set up aren't really designed to interpret arbitration clauses, right? They're designed to grant the relief. So I'm not even sure this would fit within those emergency proceedings. And so it would basically totally wipe out the value of those carve-outs.
Right.
Now, the sort of second point is, which your question about sort of default rules and what parties intend and contract interpretation alludes to, is I do think parties can fix this. And some carve-outs already, I think, reasonably can be construed as saying these are actually issues for the court to decide. But I think there's a lot of carve-outs out there that are not clear on that. And if they're not clear, then, so again, sort of, you're right that this is something that we would want the parties to be able to address. I think they can, but I think they need to do more than just include a carve-out. They would need to have a carve-out plus language saying, this is an issue. Interpreting the carve-out is not an issue for the arbitrator, it's an issue for the court. And if they do that, then they can basically override whatever the court does in Henry Schein.
Right. I mean, I think that's a fantastic point, though. One of the things I always say, draft a better contract, and I think you're right. I mean, you can definitely take care of it with better drafting, but I just wonder how many parties are really going to be thinking in that kind of, that's pretty intricate to be thinking about that at the time that you're just entering into a contract on a bigger deal, and the arbitration clause is one tiny, tiny part of that.
And especially at this point before, I mean, this is not an issue that people would have focused on now. I mean, depending upon what happens in Henry Schein too, it may focus people's attention on that more. And that's actually, so I mean, there's sort of an underlying problem here that I think makes that even more serious. And that is, in Henry Schein, like in many contracts, this is not an express delegation provision that says all issues are to be decided by the arbitrator. As you say, this is an incorporation by reference of a AAA rule that frankly doesn't clearly say that. All the circuits that have addressed the issue have now held that it should be construed that way. But as you mentioned, I'm one of the reporters on the International Arbitration Restatement. We think that's just wrong way to construe that rule in the first place. That those sorts of rules became part of institutional rules, not to make, to sort of, as a general matter, at least not initially, to switch the who decides question, but simply to make clear that the case doesn't have to stop if somebody raises a challenge to the arbitrator's jurisdiction. So there actually is some authority, mostly in American state courts, for the proposition that if somebody challenges the enforceability of an arbitration clause, the case has to stop and it has to go to court. And before anything can happen in arbitration, the court has to rule on the enforceability of the clause. Okay. Rules like the AAA rule were designed initially to prevent that outcome by saying the arbitrator has the authority to rule on these sorts of challenges. It may be that the court has the final say, but the case doesn't have to stop. Okay. And these rules, frankly, came from the international arbitration setting where all the discussions are crystal clear that's what's going on. Okay. When the AAA started adopting it into their rules, the legislative history, such as it is, suggests that's not what they thought they were doing. Even though the language they use, frankly, that's all it does, right? The language just says the arbitrators have the authority to do this. It doesn't say that they have the exclusive authority to do this. There's actually a recent Sixth Circuit case that sort of isn't persuaded by the historical analysis I just described, right. But the restatement takes the position sort of fairly strongly that the type of delegation provision at issue in Henry Schein shouldn't be treated as a delegation clause at all because it's just incorporation by reference of a competence rule.
That's such a great point. As you're talking about this, I'm thinking about the AAA rules and maybe do you think the AAA, realizing this kind of fundamental problem, would even change Rule 7, would even change the rule with respect to delegation to make it more clear that it's only with respect to certain things, not including injunctions, emergency procedures, things along those lines.
Yeah, I mean, that would be the AAA has not changed the rule in response to all the circuits lining up this way. My understanding is CPR has a model rule that you can use if you want to more clearly address who decides what issues. Now, whether the AAA hasn't changed its change its rules because all the people who use the AAA, that's what they want. I mean, I do think the parties, the sort of lawyers drafting the rules may have had that in mind. But I think in cases like Henry Schein, going back to your point about this being inconsistent with parties intended, they may well had no clue that they were actually agreeing to delegate all these issues to the arbitrator. So when they put a carve out in, there would be arguably no reason they would expect that essentially the carve out becomes worthless because of this delegation clause.
Yeah.
So again, I sort of see that as really a transition problem, depending upon how the court comes out in Henry Schein, because parties can fix it. And I do think there are some arbitration clauses out there that are worded such as to avoid the problem, but not nearly as clearly as they would need to be after, depending upon what happens again when the Supreme Court decides Henry Schein too.
From sort of a practical standpoint, I definitely think if you're in IP or in some areas where having ability to get emergency relief quickly really matters, I would be very vigilant if I were drafting a contract, right? I would really think about this issue at the outset.
Yeah, and the who decides issues are easy to overlook just because they're sort of one step beyond what you're used to thinking about when you think about a substantive provision. Lawyers, I mean, when I started teaching arbitration 25 years ago, it was you regularly would see cases where parties didn't even think about these issues as to the most fundamental applications. Here we're talking about applications that are sort of not fundamental applications. And so I'm not surprised parties haven't fully appreciated it, but absolutely going forward, when if you have a contract with a carve out, at a minimum, you need to think about, do you want the arbitrators to be interpreting this carve out? And particularly in cases with emergency relief, I can't imagine you do. So then you would need to make a very clear drafting decision to state that this is an issue for the court, that basically the court is to interpret and apply the carve out. And you do see provisions like that. I mean, class arbitration is one common setting where parties will make very clear they want the court to construe the clause rather than the arbitrator to construe the clause.
Right.
So they know how to do it. I mean, you can do it as a drafting matter, but it is not something that's been done as commonly in the carve-out setting until now.
Yeah, probably. Now here we go.
Potentially until going forward.
Right. One last question, I guess, is do you think, I mean, I agree with you, to be honest. I agree with you. The outcome is most likely going to be exactly as you state, but is there any inkling of hope? I mean, Gorsuch, for example, in the new Prime case, seemed to indicate a little bit narrower of a view with respect to arbitration. Do you think that signals possibility for a different outcome?
I mean, there certainly is the possibility. I think to get there, I mean, I think you'd really have to, the court would really have to kind of go the first principles versus Kaplan, where it sort of looks at what parties commonly would expect and when you would need to find a sort of clear and convincing evidence to the contrary.
Right.
Okay. And it's one thing to say with the scope question, the default is this, but you can override it in a particular way. Scope ways, right? Is a longer case for leaving it like the parties would expect courts to apply that up front, because the whole idea is defining what courts do. So it's possible that if they sort of are willing to think through the clause carefully, might take a more demanding view of what constitutes a clear and unmistakable agreement, possibly saying incorporation by reference, talking about defining what the court's going to decide in the first instance. The challenge is what the court decides is the flip side of what the arbitrator decides. And right. So in theory, you could make the same argument about any scope provision, and that's clearly not going to be successful. But so yeah, there is some possibility of the court being willing to look more into the intent of the parties about what these particular types of provisions do.
You never know. Strange things have happened, right? The Supreme Court has not exactly been clear in the past. It seems as though there have been kind of some surprise rulings, so you never know.
No, that's true. That's true. I don't think that's why they granted cert in this case, but maybe when they spend more time with it, they will come to understand.
Well, for the record, I agree with
there's actually more to.
For the record, I agree with you and the restatement.
Well, I appreciate that. And again, that's not the issue before this case. It just makes this case even messier.
Yeah.
So.
Well, listen, I really appreciate your taking your time with me today, and it's always good to see you and always good to talk. So thank you again.